Institute, and it addresses a number of critically important gun violence prevention issues. Additionally, the bill brings misdemeanor domestic violence convictions into the Virginia Code and more in line with the federal code as a firearm prohibitor. These are all serious crimes. They're not partisan issues. They are public safety issues. The bill will ensure that Virginia is part of the solution to prevent gun violence and prevent guns from falling into the hands of people who pose significant threat to the safety and welfare of all Virginians.
Any questions at this time? Delegate Davis.
Thank you. Delegate, you mentioned it brings in misdemeanor domestic violence. Can you point me to where that is in here, please?
I don't have it in front of me.
Delegate Davis, I think Council
Right.
reference.
I'm looking on those lines. I don't see it.
It's on 95, Romanet 3, assault and battery of a family or household member.
So, follow-up question, Mr. Chairman?
Delegate Davis.
So, in U.S. v. White, the Fourth Circuit Court of Appeals overruled that assault and battery of a household member is not misdemeanor domestic assault because we use a common law definition of assault and battery, which means I spit on you, it's assault and battery. Whereas at the federal level, when they look at domestic assault and battery, misdemeanor domestic assault and battery, it requires actual, more than de minimis touching, is I think is one way the court put it. So how does this bring that in when we've already been overruled by the Fourth Circuit Court of Appeals?
That court is counsel from
Mr. Chairman, White was overruled by the U.S. Supreme Court in Castleman 4 years after. The Supreme Court held that any misdemeanor conviction would satisfy this. So it just has to be offensive touching, which is what the common law is, which is what Virginia has. So Virginia's laws in Castleman would apply. So so White was overruled.
Follow-up question, Mr. Chairman.
Delegate Davis.
So then, if I'm understanding this properly, and I mean, I can refer to the Henrico case recently where a 13-year-old threw a baby carrot at a teacher and got charged with assault and battery. At this point, that would apply. I mean, if I have most Thanksgiving dinners where we have a food fight and it's out of anger, that would apply. That would now be encapsulated in here. I lose my rights for a firearm.
If it was a family member, then that would be a assault. If you were convicted, that could be an assault and battery against a family member.
Thank you, Mr. Chairman. Appreciate it.
Any other questions at this time? Back to the committee for discussion. Delegate Davis.
Thank you, Mr. Chairman. Mr. Chairman, I just want to make sure we all understand what's going on here. So presently, if you look at federal misdemeanor domestic assault and battery, that requires physical force. Now, physical force doesn't mean I shoved you, you fell over to the ground, hit your head, and then in a hospital. It means I so much as did something out of anger and excuse me, with somebody, I pushed someone, right? At least that, in an angry manner or some way that is threatening. In Virginia, that is not required in assault and battery. And all of our cases show that, which is why White was overturned. Now, I understand it got looked at again, but let's understand, when you want to look at what assault and battery is in Virginia, in Lynch v. Commonwealth, it says that the person that the slightest touching of another, or of his clothes, or cane, or anything else attached to his person, if done in a rude, insolent, or angry manner, constitutes a battery for which law affords redress. If you take it a step further, when you look at Wood v. Commonwealth, it is not necessary that the touching result in injury to the victim's corporal person. It is sufficient if it does injury to the victim's mind or feelings. This is what we're actually going after here. So, Mr. Chairman, I can appreciate what we're trying to accomplish here, but I would argue that any type of violence that already exists when it comes to assault and battery is already encapsulated. What we're trying to say is, you have an angry food fight at Thanksgiving, and your cousin gets upset because you threw literally a baby carrot at them. They can bring up on assault and battery charges. And I know that sounds absurd, but that's exactly what happened to a middle school student when a teacher was actually hit with a baby carrot. So let's just be careful that we don't wrap a circle around a whole bunch of people that make a political point and end up putting them in jail, or and just as bad, taking away their constitutional rights.
Mr. Chair, just speaking to the motion, it seems that there have been some concerns expressed about our misdemeanor laws around assault and battery, and I would offer that the proper place to deal with that is by adjusting our laws in assault and battery rather than protecting the gun rights of those who commit assault and battery.
Mr. Chairman, I would just, if I may, I would just mention to the delegate that they are proper up until this bill. Right now, if you have what the federal government defines as domestic assault and battery, you do lose your rights to own a firearm under federal law. It's by doing this that you lose them by throwing a carrot at your cousin.
Delegate Glenn.
I move that we report the bill.
It's been moved and properly second to report the substitute as amended, House Bill 1288. Clerk will open the rolls and members will cast their votes. Clerk will close the roll. House Bill 1288, recommended report by a vote of 5 to 3.